Yeah, okay. Yeah. I don't think so. I contact you. Yeah, email me and just make a note of it.
Well,
Okay, thanks. Yeah, because I thought.
yeah, I think that was on my end. I'm sorry.
Oh, it's okay. Oh, yeah, you can. Oh, no, 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 you're
System
fine.
going.
Yeah, yeah, yeah. Oh, well, yeah, okay, cool. Thank you so much.
And I tried to take hers and she wouldn't let me. She's like, I'm gonna eat it. I'm like.
What happened to Dan Daniel? You remember that?
Yeah.
Oh, nice, nice. That's from But then we did
Oh, cool. I'll put some of these around. Thanks.
So I have to do much more stuff.
What kind of case is it?
Yeah, thank you. Thanks. Appreciate it.
Do you want anyone to copy that on signature in the back?
Oh, no, it's fine, as long as it's on there somewhere.
No, you can take my bags.
Okay. Oh, yeah, no, I'll take it. Thank you so much. Okay, thanks, appreciate it. We all started attending shoe. Thank you. All right, I've got 7, so I guess we can go ahead and get started. I thought I'd start with just kind of a quick update on the schedule. I was thinking about good news and bad news, but then I realized if I was a student, it would just strike me as good news for you, which is that next week's class is actually going to be canceled. And that is because I'm going to California for my wife's aunt's 65th birthday party. Which doesn't sound that fun, but I kind of am in love with California, especially in February. So I'm going to be out of town. So as far as making up classes, you know, I was thinking we could make it up in a couple of ways. One is to formally say that this class will go until 8:45 as opposed to 8:40, which is a 5 extra minute extension. Now, formally say meaning like, oh, when somebody asks how we're making it up, we're going to add 5 minutes to each class. I mean, sometimes we're going to end early anyway, but like, so unless there's an objection, I think we can say like, oh, the class now goes till 8:45. That'll allow us to make up maybe 35 or 40 minutes. And then what we're also going to do, and this was going to be part of the class anyway, is that at some point in the semester, and it'll probably be coming up soon, we'll have 2 conferences. One will be a phone conference that you and I will have during the course of the week. And so I'm guessing that I'm slated to set those up after we deal with motions to dismiss, which is a substantive area of the course that we're going to talk about after we get through answers. So early March, you know, maybe not next class. Well, maybe next class, I'll pass around a sign-up sheet where we will have one-on-one phone conferences. And the thought is that we will then talk about your complaints, your answers, your motions to dismiss, some of the other shorter assignments that you've done, and just kind of get a sense of how you're doing. I mean, it's just a quick check-in. It's not like a long conversation. But it allows us to kind of count that time as substantive, kind of course-related work. And then towards the end of the semester, we'll have an in-person conference where I will come. I'm not sure which day. It may be a Monday. That probably would make some sense, and then I could just stay for class. And we will just do maybe like roughly 30-minute conferences where we just do one, I do one after another. And then we can meet in person and talk about kind of all of your substantive writing assignments to date with a thought that that might be helpful in advance of that final portfolio project that you do. So we can then count that time. So if we add 5 minutes to the course, quote unquote, and then have those two conferences, one by phone and one in person, I think that's more than enough time to make up the one missed class that we'll have. So we don't have to have like a makeup class, which frankly nobody wants. You certainly don't, and I really don't either. So how does that sound? Any objections to that? Okay, so what does that mean for the schedule? Well, I've updated the syllabus to include today's course. Let's just take a quick look at that. So if you maybe walked in a minute late, we're not going to have class next week. And our next class will just meet the following Monday. So the syllabuses remain the same. We've now just updated the class schedule. This was last class, was class number 5. This, of course, is today's class. We're going to review the drafting exercise, which was on, you had to draft a complaint, the first upon complaint. And then after we do that, which will take a decent amount of time, we will then discuss the reading material and answers. You will then have to you will have to review a case file and draft an answer. And instead of that being due this Saturday, since we're not going to have class, I thought, well, we might as well just have that due the following Saturday, which is February 29th. I actually have not yet posted that. Kind of full disclosure, part of the reason I haven't is because today was a federal holiday, and so I wasn't in my office like I normally am. Plus, I want to kind of look at some other things and maybe add one or two things to the case file. So my plan is to upload that by Wednesday at 5. And I thought if I uploaded it by Wednesday at 5 o'clock, that would give you 10 days to work on really what might be one of the easier drafting exercises. Drafting an answer, I think, is much easier than drafting a complaint. But nevertheless, you'll still have more time than you normally have. So what I will do is by Wednesday at 5 o'clock, I will upload this drafting exercise, which will be due Saturday, February 29th at 5. And when I upload it, I will also send out kind of one of those blast 20 emails that's like, hey guys, the drafting exercise for the 29th is uploaded. The reading assignment, though, is already uploaded, and that includes just 3 little packets. You can find that under reading assignments. If you go to the drafting exercise, you'll see that I've included the folder, but it's empty, and I will add that by 5 o'clock on Wednesday. The reading assignments, though, to be completed before next class, which, if you look at the calendar, is actually not until March 2nd. There are 3 documents here. One is motions, which comes out of this Temple Smith and Couples casebook. This is kind of the landmark's not the right word, but the kind of key casebook that we use and pull material from. But there's also this Fahens, Falk, and Shapo reading assignment on motions to dismiss. And then, of course, Rule 12 of the Federal Rules of Civil Procedure deals with motions to dismiss. And so I wanted you to take a look at that as well. So the plan going forward is no class on Monday. 1 week from today, we will have class 2 weeks from today. And I will upload the drafting exercise by 5 o'clock on Wednesday to be due on February 29th at 5. And then your reading assignment for next class. Any questions? It'll be a nice little break. Even when the reading, the drafting exercise is posted, you'll see answers are not quite as difficult. It will be basically responding to not the complaint you did. It will actually be a new complaint that you'll be given that will be poorly drafted. And then you'll have to draft an answer to that, which includes admissions, denials, or maybe lack of knowledge with respect to specific factual allegations. And then you may have to assert an affirmative defense or two in your answer. So not too bad. Any questions about that? Comments, concerns? So I'm kind of excited to go to California. It'll be warmer. I looked at the forecast, it said 70. Although today it's like 50s here, so it's not too bad. All right, so let's look at this drafting exercise. This was an updated Portia Pond fact pattern. Updated in the sense that you've already looked at a fact pattern related to these facts, and that was for assignment 2, but this is kind of an updated fact pattern that gives you a little bit more to go on. And I thought what we can do is kind of discuss it as a class. I'll call on you or you can volunteer, and we'll just kind of build the complaint. I looked at all of yours, reviewed them. I thought they were really good. There were some factual allegations that I thought were more detailed than others. I thought, we could have maybe separated out some of the factual allegations with respect to some of you, and then there were different strategies that students used with respect to headings or transition sentences, the extent to which you use legal conclusions. As we kind of discussed last class, there's some flexibility there, but what I thought is we could kind of, as a class, build a complaint, I'm not going to put word for word on the board, but kind of put the key portions of the complaint that you would want if this ended up being a complaint that you filed in federal court, or just for our class purposes, if it ends up being not just a complaint that you draft for this weekly assignment, but also one that we target as kind of a final drafting exercise. So let's see. Does anybody want to help me out? The first question I had is, how did you kind of begin your complaint? Anybody?
In terms of like the heading and everything?
Yeah, well, that's the first thing you would need, right? It's Mitchell, right?
Yeah.
Yeah, okay, so the first thing you would need is what? A caption.
Yeah, which would
Right.
be your, whatever jurisdiction you're in.
Yeah, of course. So the first thing you would need is here, and what jurisdiction, and what court are we in?
Kentucky, and then there's Caledonia County.
Yeah, Caledonia County, and do you remember which court? There were a couple
Superior.
of courts. Yeah, Superior Court, good. So in the something like, you would want a caption, which instead of writing it all, I'll just say it. You would want something like, in the Superior Court, Caledonia County, Kentucky, right? Notice that that was different than what you saw in some of the sample complaints that were in the file previously, like in Kentucky. You want to make it clear which court this is being filed in. It sounds interesting, or it sounds easy. You'd be surprised how many attorneys miss that. Pro se litigants miss that all the time. They're like, federal court, Bowling Green. And I'm like, well, that's interesting. This is Lexington. But they'll just get it wrong. And even attorneys, I think, just kind of leave out that important kind of caption. And then, of course, you would want what next, Mitchell?
Then you'd want, on your left side, you'd want the plaintiff's name, or identify the plaintiff, which would be, I think it was at Portia Pond.
Yeah.
Then I think some of us put doing business as whatever.
Old Town.
Exactly, yeah. Now, there's kind of two ways you can do this. I mean, this is kind of boring and technical, but you could say plaintiff Portia Pond, doing business as Old Town Cleaning Services or as Old Town Commercial Cleaning Company, which is what most of you did. The only alternative would be to say something like Portia Pond doing business as Old Town Commercial Cleaning Company, plaintiff. I don't think it makes a difference. The only thing I would say, and if there were a couple of you that I think you need to kind of take note of this, you want to keep it consistent, right? So if you start with the word plaintiff here, you'd want to start with the word defendant here, right? So if you do plaintiff Portia Pond doing business as, you would want to do versus defendant Philip A. Grantham, doing business as Grantham's Jewelry Store. Or you could say, Philip A. Grantham doing business as Grantham's Jewelry Store, defendant. You would just want to keep it consistent. And then, of course, case number here, which I didn't really give you, 1, 2, 3, ABC. And then you would want a line here, okay? Then, of course, you would want the title. There's some flexibility there. Complaint for damages, premises liability, complaint, civil complaint. I think there's flexibility. But you would definitely want a title, and then you want your commencement language, which is what? Mitchell.
I'd say plaintiff Portia Pond doing business as, or just plaintiff Portia Pond.
Yeah.
Sues defendant Philip A. Graham and alleges the following, colon, and then.
Yeah, I think that's right. I mean, I think you don't necessarily need, I saw a lot of people do this, I don't know that you need all of that again with respect to the doing business as, just because it's already been defined once, right? I mean, I think that's kind of the just a principle of legal writing, which is once you define something one time, I don't know that you necessarily need to define it over and over again. Yeah.
So in lieu of defining it in the top caption area,
Yeah.
you just do it in the body instead.
I think you should do it in the caption.
Okay.
I think you should do it up here, because that's kind of the key operative area where you would define the plaintiffs and the defendants. I think that as a general matter, if you're going to have a doing business as, that's almost always put up here in the caption. So are AKAs. You see that a lot in the kind of case law that I deal with, which is interesting. I don't know. It's always like, plaintiff John Smith, also known as Mad Dog Smith. You'd be shocked. It's like on the BOP inmate locator. It's like Mad Dog. I'm like, oh God, what's he in for? So AKAs, though, those are typically also put up top. So I think that's the preferable way. I mean, I don't know that that's like a hard and fast rule, but I think that's something you would want. The key, though, with the commencement language is you want it kind of short, sweet. You don't want a bunch of parentheticals, something like plaintiff Portia Pond sues defendant Philip Grantham and alleges, and then we need to get into the meat of it. Now, what's the first kind of... Notice that none of this includes factual allegations, right? This is just kind of the stylistic stuff. What's the first kind of ultimate fact you want to allege? This is also the most boring part of the class, too. I mean, if you're like, this is super boring, it is boring. Like, this is way more boring than drafting like memos or emails or judicial opinions, which I think are much more interesting. But, civil litigation isn't always the most fun. So, okay, what's the first substantive allegation?
I would do jurisdiction.
Well, yeah, I think you need to do jurisdiction, yeah. You've got to make it clear that the court has subject matter jurisdiction. So this is going to be your first allegation, and how are you going to allege it?
I would allege first, Portia Pond is, throughout the entirety of the event, was a resident of Caledonia County and then did the same thing.
Well, now that's interesting. Do you think you need that kind of information? Because do you think that goes, you're talking about for diversity purposes?
Yeah, I would think for
Yeah, I think that's interesting. You could allege it that way. I think you could do that. Most of the complaints that I see kind of would start out with the amount in controversy, and it would become clear from the facts that Portia Pond, is a resident of one state. Well, but here's what I would go back to. Now we're kind of mixing metaphor. We're kind of confusing things. Diversity jurisdiction is relevant for what?
usually federal court.
For federal court. Now, are we in federal court here? No. So I think if you were in a situation where the claim was one that was being presented in federal court because it was diversity jurisdiction, then I think you would need allegations related to both the citizenship of the parties and the amount in controversy. Here, though, we're in this superior court in Kentucky, which is, like a functional state circuit court, Jefferson Circuit Court. So really, the only issue I think here is, do you meet the amount in controversy threshold? Not in a subject matter jurisdiction federal court situation, but just in a, can I get in a state court here? And so because of that, I think you really just need something like this action is for damages in excess of $20,000. So that's how I would start it. Now, why not give the specific amount? It says in G in the fact pattern, let's see. Well, we can stick with you, Mitchell. It says in G, Portia has accumulated over $125,000 in medical bills. Why not allege that?
I think it's because you don't know if that's going to be the final. Don't just specifically say we're asking for $125,000 because you don't know if A, that's a final number, and B, I think also we talked about. I think there was part of it in the memo that said there's specific ways that you have to. You're talking about not doing punitive damages, and there were a couple other rules about damages.
Yeah, what was the other rule? Yeah, you're on it. I mean,
general is don't. I think it was something that agreed. Don't list specific numbers.
Yeah, it prohibits it. It says Kentucky law prohibits stating the amount of general damages in the complaint. So I think we had a couple people I noticed who kind of put the specific amount. I do think you're right that you want to kind of keep it open too, that strategically for the plaintiff, it might be beneficial to kind of keep it ambiguous, but you're also kind of required to, yeah.
So I was confused about that when we were doing it. And it's so no good to say this is how much her medical expenses are?
I think that if, to the extent that what you're pleading is an amount in damages, I think you ought not state the specific amount.
Okay.
But
I was on the fence.
well, it's interesting because I think what you're going to is the trying to maybe draw a distinction between the damages she suffered and the relief you're seeking.
Yeah.
Right? I mean, in theory, like you could maybe say, oh, she suffered $125,000 in damages without seeking only that amount. I think the better practice would be to just leave the amount off to avoid confusion and just make it clear that the amount in controversy is for more than $20,000. And then plead that she has, accumulated, you could say, an extensive amount of medical bills, or you'd want to be a little bit careful in the way you plead it. You know, I don't know. I'd have to think about that. I don't know that that's deficient there. If you pled over $125,000 down in the damages section, which is what I think you did, if I remember correctly.
Probably,
Yeah.
Look at it.
But you wouldn't want to kind of state it specifically up front as the basis for the court's jurisdiction,
Yeah.
if that makes sense. But you know, I kind of would hesitate to say she's accumulated an extensive amount, because what is that? I mean, my definition of extensive is less than, like, you know, Mike Bloomberg's definition.
Yeah.
Not to pull Bloomberg into this. So anyway, yeah, so that's what I would say. That's the first kind of substantive allegation. What's the next one? What are we next starting to think about? That's good. So Mitchell, you've been helpful. Let's see. Let's go to somebody else. Who else wants to help? Hannah, what about you? Let's go down the row.
I went into identifying the parties, like so at all times relevant plaintiff George Upon was a resident of Old Town, and then the defendant owns, operates, maintains, Scranton Jewelry Store, and then where it's located.
Well, I think that's right. I mean, I definitely think you want a number of allegations here. I mean, I'll just kind of go here. But why, you said identify the parties. Now that's interesting. A lot of people said, like, identification of parties in their complaint. They would have a heading. A few of you had that. But why, what are you doing there? What's the, just to say, like, hey, intro, this is who the players are? Or does it serve, do those allegations serve another arguably more important functional purpose and formal purpose?
I mean, I know like it could prevent the defendant. I mean, at least at work, like we do it to prevent the defendant from trying to remove it up to federal jurisdiction.
Yeah.
But
Well, let's talk about that. Why? How could a defendant? It's not necessarily relevant, but I mean, how could a defendant remove a case to federal court?
if they were, like, if there was diversity. Like,
Yeah, that goes to your
Yeah.
point, which is like maybe if it was filed in state court, but the reality is there was diversity of citizenship, and the amount of controversy appears to be more than $75,000 in damages, then you could have a defendant remove it. So yeah, I mean, I think there's an element of that for sure, like a practical element, like, hey, I want to make it clear, like, these are two Kentucky parties. But is there any other relevance to it? Like identifying the parties, like, hey, this is a person who, you know, Philip, I said something like, at all times relevant to this cause of action. I started with the defendant just because I felt like the defendant's the owner of the business. And I said defendant Grantham owned and operated Grantham's jewelry store located at 212 Tennant Street, Old Town, Kentucky. And then I had number 3, at all times relevant to this cause of action, plaintiff was an independent contractor who owned and operated a cleaning business known as Old Town Commercial, blah, blah, blah. And then I had another allegation. Since 2015, plaintiff has provided cleaning service to defendant's jewelry store. Same thing. There's a lot of flexibility there. But I mean, I think you need, I would say 1, maybe 2, 3-ish, 2 or 3-ish allegations. I had kind of 3 say this is who the defendant is, this is who the plaintiff is, this is, since 2015, the plaintiff has provided cleaning services. So about the defendant, about the plaintiff, about the nature of the relationship between the parties. And I think you're right, Hannah. You're saying this is all about kind of laying the foundation, maybe making it clear you've got 2 non-diverse parties. But I'm saying, is there any other kind of formal purpose that these allegations are serving beyond what you're saying? Can you help us out, April?
No, I'm
Can I-
I'm just thinking it's jurisdiction. I mean, we're showing
Uh-huh.
jurisdiction is proper here, but
I
that's.
think you're not wrong. I mean, I'm not saying that's wrong. I'm saying these allegations, Anthony, what do you think, might serve an additional purpose?
Aside from introducing the parties and satisfying local rules.
Yeah. I mean, what type of case is this? Yeah, over here.
I think it,
Kirby. No, you're Kirby. Michael.
it goes starts going towards the element of
Duty.
Liability action, because you have to establish that the business owner arranged for a person to provide the cleaning services. So, especially if you have that number 3 up there, you're starting down.
Yeah. I mean, I think this does go to the element of duty too. You're not wrong. I mean, and I think you guys, it sounds like I have some experience drafting these things at firms, and that is right. I mean, in most of these cases, it may be just in almost all complaints, you're going to have some sort of foundational statement about the parties. But what's interesting in this kind of a case, Any premises liability case, Kroger. Oh, let me tell you about who the defendant is, Kroger. Let me tell you about who the plaintiff is, Colin Schuler. Let me tell you about, on this day, Colin walked into Kroger. That is just setting the foundation for the rest of the allegations. But it also, in a premises liability complaint, those are allegations. By the way, I misnumbered these. These should now be 2, 3, and 4, which is actually important. But these are allegations that go to the element of duty, right? Because only certain defendants, individuals, entities owe duties of care to certain plaintiffs, right? And where is that? How do you know who owes a duty of care to, Michael? I think you touched on it.
In the rules of procedure for Kentucky.
Yeah, and that memo, that really kind of boring memo. That's like number 6, elements in a premises liability action. In Kentucky, a person who owns and operates premises has a duty to use reasonable care to make those premises safe for a business invitee. And remember we said last time we put this memo out, it was a little ambiguous, like what's a business invitee, what's not, who is not. And so we kind of clarified under Kentucky law, if a business owner arranges for a person to provide cleaning services, that person is considered a business invitee. So now that may be down here, right? So up here you might have at all times relevant to the cause of action, defendant owned and operated the jewelry store, which was located here. The plaintiff was an independent contractor who owned and operated a cleaning business known as this, which goes to your point about kind of the doing business as, but I think that's a way you can say it without redefining it specifically or per se. Down here, I think you would want to say something like, since 2015, plaintiff provided cleaning services to defendant's jewelry store. And maybe it is more this that's the duty, but really you kind of need all 3 to make it clear who owes a duty.
I have 2 questions.
Yeah, sure.
Venue was in our stuff, but we didn't talk about it, and
Yeah.
so is it improper to say something about
No, it's not required. My understanding is it's not required. If we look back at the reading material, in most instances, you're not required, and in fact, in some jurisdictions, you're not supposed to plead venue. Let's look at that if you've got it up. It's the reading assignment on the initial pleading. It says, Federal Rule 8 does not require the pleading of venue, but many lawyers prefer to plead the facts establishing the basis of selected venue. Venue rules differ among the states. I don't know, did the rules say...
It just was in the pack. I mean,
Yeah.
It's in with under jurisdiction. I mean, the small thing we had, it was in there.
Yeah, you're welcome to plead it, and a couple of you did, a couple of you didn't. If you want to plead venue and the rules don't specifically prohibit it, then it's kind of up to the lawyer's discretion.
Okay.
I'm so used to the federal rules that say don't plead it that I typically don't unless I'm told to, and I don't think the rules make it clear that you're supposed to, but that you're welcome to. And I think the same is true in Kentucky. I think in most civil complaints that I've seen filed in Fayette Circuit Court at least, and it's been a while, they usually do plead venue. But for our purposes, I didn't require you to put it in there. But if you did, you're welcome to. And where would you have put that?
I had it like short, like the action is for damages in
Mhm.
excess of $20,000.
Yeah, subject
Then I'm
matter
like,
jurisdiction.
Ranthams is located in this district, and then venue's proper because
Yeah.
this is where it is. Then I went into the 2, 3, and 4 that you would have.
I think that's fine. All I would say about that is if you do plead venue, I would make sure that it doesn't get interwoven with the elements of the cause of action. Because I think the minute you start getting into duty and breach, you want to kind of keep going with that. And so I thought that there was a few people I thought kind of mixed up this idea of duty and this kind of throat clearing introductory language or maybe venue type pleading. As long as you've got that, I think it's fine. And that's also, to be honest, an area where I think, especially for young associates, headings can be very helpful. Because then it's clear to everybody, like, look, these allegations that I've got here, whatever it is, these numbered allegations, are trying to prove up this either procedural issue, like subject matter jurisdiction or venue, or kind of this element of the substantive cause of action. So I am a big fan of headings, which I guess means you should be since I'm teaching the class. But I don't think it's, there's legal writing and drafting too. There's no one right way to do it. I mean, there are things you can do wrong, like not write the proper court. But I think there's some stylistic choices. If you want to use kind of transition sentences as a way of kind of making it clear what element you're going to, I think that's fine too. I just think it's cleaner, especially for students and young associates, to do kind of headings. So what I did in mine, I didn't do title and commencement. There is a title, there is a commencement, but I started with A, subject matter jurisdiction, number 1, and then I went to B, duty, but I continued. Remember, the numbers should stay consistent because the defendant has to respond to each of the substantive allegations. So then I had C, breach. And I think you got to be a little bit creative. You can even have subheadings within that, but then you got to be careful. If you start numbering that, then you could have a problem, because then it's like, what you could do sometimes is like just a bold, like breach, offset this, like center this, bold it, and then you could maybe italicize, like hazardous condition. But you got to be careful with headings, because I know it sounds crazy or it sounds so elementary, but you'd be shocked how many students A's turn to letters turn to numbers, which turn to, and then that confuses the allegations, and that's the last thing you want, is unclear kind of headings. Pick a format for your headings and just stay consistent with it. Okay? Yeah.
So commencement is not a heading, though.
Commencement, I don't think is a heading.
Okay.
I mean, could you write? Some
have
of you did. I don't know if you did, but some of you did. And I think commencement is just kind of like not a heading thing. I don't know, that's not like
And then
commencement, plaintiff. I don't think you need that. Yeah.
I want to talk about 2015.
Okay, yeah.
I didn't want to put a number on the year in
Yeah.
there, because I feel like that might be an easy way for them to say, oh, I don't remember, or something. I guess that's silly though, because they would be able to look back at their records. So
Yeah.
is there a preference between saying approximately 4 years and the actual year?
I don't think so. If you have a good faith basis to believe that that's an accurate statement, we're going to talk about how defendants have an obligation, with their obligations with respect to answers. But like the reading material comes to mind when Temple Smith and Couples say an attorney should use the response that the defendant lacks sufficient knowledge only when the defendant truly lacks sufficient knowledge. I think there is this kind of fear, especially among young attorneys, to like plead it in such a way that can avoid them denying anything. And I think like if she's worked there since 2015, I mean, she has. She either has or she hasn't. So, I would be more concerned about saying things like I just said to Demetria, like just because I was thinking, excessive amount of medical damages. Well, that's ambiguous, right? If you've cleaned something since 2015, like I think they have an obligation to kind of comb through some of their own records. They can't just be like, well, that might be wrong. We're not going to look at our files. Like, I don't think that they can do that. So that wouldn't concern me as much.
When I was drafting it, I was just remembering you saying, don't get locked into the date. And
No,
so
yeah. Well, and I don't think that date necessarily.
it's not a date, it's just
No.
a year, and
Yeah.
so.
You could just, or you could have pled something else. You could say, plaintiff has had an agreement with the defendant to provide cleaning services over the past few years. I mean, but then even few, like, I don't know. I mean, I think I would just say since 2015, just because it's a clear fact that's kind of undisputed, as best as we can tell. You could say just plaintiff provides cleaning services. I don't know. Those really, there's a lot of ways you can. There's no one right way to do that. That's also that's not really where the media is going to be fought, right? It's going to be all fought over like what was there. I don't know that a defendant in a case like this is going to be objecting too much to the duty elements, right? Because especially when the case law here is so clear that, look, if you have an independent contractor who comes onto your property to clean your business, like you owe them a duty of care because they're the business invitee. I think the real question is going to be, did you breach your duty of care? And really, we need more facts. I mean, these are kind of very element. I mean, I don't mean to suggest it's not difficult, but like this is a very kind of stripped down version of facts just to get you thinking about drafting in a technical way. But a real case file full of facts is going to have all sorts of things that are good for the plaintiff and not good for the plaintiff. Like, oh, well, there was a sign there, and they had warned her. She had warned them, but they had warned her. And to what extent was she contributorily negligent, which you may have to think about when you're pleading your affirmative defenses, or did she release them from liability because they were like, oh, we'll pay your medical bills, and she didn't tell you that when she came to you and your paralegal. So anyway, the point here is that I think you want a title, you want a commencement, you definitely want to plead allegations with respect to subject matter jurisdiction. I think there's a little bit of wiggle room here into how you have these first few allegations, but you would definitely want to identify who the defendant is, identify who the plaintiff is, and identify the fact that the plaintiff has been working or is providing cleaning services to the defendant. Because it not only provides this kind of introductory benefit, but it also goes to the elements of duty. And you could even add a fifth one if you wanted to, and some of you did that here. Whether it goes under duty or breach is a little bit gray, but I said under duty, I said on November 1st, 2019, plaintiff went to defendant's store to provide cleaning services. Kind of further establishing that like this is when the incident happened, which I do think at some point, if there's a tort type incident, I do think you're going to have to be specific at least once with the date. And that's to avoid a statute of limitations problem, to make it clear, like, we're well within in Kentucky, it's probably going to be a 1-year statute of limitations. We're well within that. What next beyond that are we looking at? Allegations establishing what?
Breach.
The breach, yeah. So I had C, breach. You could also, some people might just do like subject matter jurisdiction and have a set heading there that's doesn't have a letter, and then they do A, duty, B, breach. I mean, I could see the benefit of that because then it kind of keeps you straight. Like duty seems like it should be the letter A. There's flexibility there with that. I just did it like this because I think that's the first heading I had. What about breach? I mean, what are you alleging here?
I started that section when plaintiff entered the employee break room to clean. She slipped and fell on jewelry cleaning solution on the floor.
Yeah, I had that. I actually broke it up a little bit more. I said on that date, plaintiff went into the employee break room, comma, one of the areas she had previously agreed with the defendant to clean.
So, okay.
And then I had a separate allegation about her slipping. Now, could you put it all together? I think typically we want to just have, this is not, again, flexibility. The rule is not you can only have one sentence, capitalization, a period, in an allegation. You can have more. But the minute you start to include multiple allegations in one numbered allegation, you run the risk of, if one of those is wrong, either or, you could just get a denial coming back. So I'm kind of a fan of just keeping it like tight and clean and one by one. On that date, plaintiff went into the employee break room.
Period.
You
Is
could
that
do
what you-
period there.
Oh,
I did.
I
Plaintiff
was
went
asking.
into the employee break room, comma, one of the areas she had previously agreed to clean.
Okay.
But you could, there's nothing wrong with plaintiff, on that date, plaintiff went into the employee break room, period. This was an area she had previously agreed to clean, period. And just do it like that. The real question I think you've got to ask yourself is, if you do kind of a comma and you're including multiple phrases, are you including things that you at all are worried that the defendant is going to deny? And I don't think there you really are. I don't think, we'd want to know more facts, but there I think you're kind of in a safe space alleging multiple things. Now, along those same lines, I think Hannah kind of made the point that she also alleged in that same paragraph, that same allegation, that she slipped and fell. That to me seems like something you'd want to allege separately. Is there a dispute over that? Not that we know of, but we also don't have the defendant's side of the case. So I would do something like she went into the employee break room, one of the areas she agreed to clean, and then number 7, mine was she slipped and fell. Plaintiff went inside the break room and she slipped and fell on jewelry cleaning solution that was on the floor. Now, could you get really cute and say, she slipped and fell on jewelry cleaning solution, period. The jewelry cleaning solution was on the floor. I mean, you could do that. But again, the point is the real thing, what am I looking for? What I'm looking for is that all of the allegations are written in a way that if you compare it to the memo that includes the elements of the cause of action, you've proven up sufficiently, or alleged, I should say sufficiently. Proven would be like a subject matter, or a summary judgment type standard. You've alleged enough facts which, if true, would make out a cause of action for premises liability. And most of you did that. There were a couple of issues with the breach, but we'll talk about that. Okay, so any questions about that so far? What's next after that? After alleging that she went into the break room, one of the areas she previously agreed to clean, and she slipped and fell on jewelry cleaning solution that was on the floor. What did you say next?
Defendant was aware of a problem with jewelry cleaning solution spilling or leaking onto the floor with the break room.
Yeah.
Just going into the elements of the premises liability.
Okay, well, let's talk about that. You're going into what element? You're in breach. You're in the world of breach, right?
Yes.
And breach requires what?
The existence of a hazardous condition.
Okay, now stop there. I mean, this is me with two kids, like being super paternalistic, not just at home, but here. I wrote even this, like the statutory language, it's not statutory, it's a common law cause of action, but I wrote the elements in a way that's like even further broken up, which is first, under breach, you want to include elements that establish the existence of a hazardous condition. Now, you've got that you walked into the break room and slipped and fell, and that there was jewelry cleaning solution on the floor. Is there anything else there, though, in the fact pattern that goes to the existence of the hazardous condition? I mean, it's kind of tied up with the notice. I think you'd want to say someone left a 5-gallon bucket of jewelry cleaning solution in the area near the sink. And I think you can allege that the bucket had either leaked onto the floor or a spigot attached to the bucket had been left in a position that caused fluid to drip onto the floor. Now, they may dispute that. I mean, they may they're not going to, this is civil litigation, they're not going to just admit it all. Like, denials are coming, baby. They're coming. So, like, don't not plead what you believe happened, right? Because I think that's the hazardous situation. I mean, you slipped on jewelry cleaning solution. That's not enough. You gotta say, what's the hazard? The hazard is there's a big 5-gallon bucket of jewelry. Who does that? That's insane. Oh, we'll just leave it open. Here's your coffee. I mean, that's insane. It's okay. I shouldn't. You know what I mean? Like, that's insane! Like, no, who does this in class? Nobody. I'm kind of insane. That's why I may not teach again if they see this. But you know what I'm saying? Like, nobody does that. So you would want to allege that. Now, they may dispute. I should feel bad now. They may, see, look, I've got this. I'm playing this in the break. They may dispute that, but I think you would want to include not just allegations that the plaintiff went into the employee break room in one of the areas she arranged to clean, and not just that she slipped and fell on jewelry cleaning solution that was on the floor. But I did an 8 and a 9, which for me was something like B. Basically, the two sentences in B broken up. I just said, someone had left a 5-gallon bucket of jewelry cleaning solution in the area near the sink. The bucket had either leaked onto the floor or a spigot attached to the bucket had been left in a position that caused fluid to drip onto the floor. I alleged that. And what I was thinking, and I didn't include a subheading because I get worried about like, oh, subheadings get confusing. But what I was thinking when I drafted mine was to the side I've got the elements of the cause of action, and I'm thinking these go to the existence of the hazard. Does that make sense? That's what you've got to do. See, in the real world, you're going to have a case if you're representing a plaintiff. Maybe nobody does plaintiffs work. I think plaintiffs, I've never done it, but I always thought it'd be cool to do. It seems like you could maybe like get a lot of not money. I mean, I guess whatever. But like, it can be rewarding. You can provide a service to clients who have suffered damages, harm, and do something noble. Anyway, the reality is when you're drafting a complaint, you've got to first figure out what the elements are of your cause of action. That you're being given it, because the purpose of this class is not for you to go out there and, we're testing you on employment discrimination. No. It's to, if you know the elements of employment discrimination, you can then take facts and plead each of those elements, right? So that's what you've got to do. You really have got to hold on. Like, you ought to have highlighted that number 6, elements of a premises liability, and your complaint should really track those elements well. And so what I did was, I'm like, okay, I've got duty. Now I'm on to the number 2 here, which is breach. And I know I want to include the existence of a hazardous condition. And to me, all of those facts were relevant to the existence of a cause of action, of a hazardous condition, excuse me. Now, you want either that the defendant knew or had sufficient time to become aware of. Now, you could try to subheading that, right? Maybe you just, for your own purposes, type it in your computer and then you erase it, but just so you get all of the elements. And it may sound like, why are you so worried about that? You're so worried about that because if you miss something here, then you're running the risk of a 12b6 motion coming in. Oh, you didn't properly allege that we knew anything about it or had sufficient time to become aware of it, which is a critical element. It's a necessary element of the cause of action. So what facts go to the defendant's knowledge, Hannah? That, I think, goes to your question, or your answer. Does that make sense? I think you touched on it a minute ago.
I just said he was aware of the problem with the jewelry cleaning solution spilling or leaking onto the floor of the razor.
Yeah, you would want something like a 10, which starts to sound like C, right? On 3 prior occasions, Porsche had cleaned up fluid from the areas around the bucket. And then I had an 11 that said, on each of those occasions, after the plaintiff cleaned up the fluid, she specifically told Mr. Grantham about the fluid that had been on the floor. Now, he may dispute that, but you're going with that. If you've got a good faith basis to believe that, and that's your case, plead that. Plead that. I mean, go with that. That's a strong case. And it goes to his knowledge. Not just that he had sufficient time to become aware of it, but that you told him this was an issue. Okay. Now, the next one's a little bit gray where it falls under. Does it fall under notice or knowledge, or does it fall under fail to remove, repair, or correct? But somewhere after that, which I think goes to the notice and knowledge element, this whole knew or had sufficient time to become aware of it, those allegations, I then alleged that the break room was under the exclusive control of Mr. Grantham and his employees, and the break room is not accessible to the public. Now, it's not clear that that goes to his knowledge. It kind of does in a way, but it also kind of comes to he failed to remove, repair, or correct it, because it kind of establishes that he was in a position to. So I think you need those elements too. It's a little bit ambiguous as to where they fit, but I think they kind of help the story along at the very least. But what you're going to want after that are facts that go to elements 2B. Element 2B, which is that the defendant failed to remove, repair, or correct the condition, or failed to make reasonable efforts to warn. What did you say there? Because what's interesting, Hannah, is that it's not really in the fact pattern. But did you allege facts there?
I did not, but you could say there was no what floor sign.
Yes, I think you need that. I sound like an asshole. I'm like, you need that, Hannah. You're like, I didn't play. I'm like, you need it. I'm gonna throw in more coffee. No, I mean, you need it in the sense that breach requires both the existence of a hazardous condition that the defendant knew or had sufficient time to become aware of, and the defendant didn't do anything about it, right? And so, I mean, who knows? Maybe if you don't include that, who knows? He may come back and say 12b6 motion. They didn't allege that I didn't do anything about it. And in fact, we did do something about it. We cleaned it up. Now, why she slipped and fell is beyond me, but you would want to allege some facts with respect to failure to remove, repair, or correct the condition. So one thing you could say, and this kind of is going to the 2B element, is something like defendant and his employees failed to replace or repair the leaking container, or failed to place the container in a location other than the areas where plaintiff was working. I mean, there's a lot of flexibility here. I also had defendant and his employees failed to warn the plaintiff that the container was still in the break room after plaintiff had told the defendant that the container was leaking onto the floor. See, I would include both. What's interesting about 2B is that if it's defendant failed to remove, repair, or correct, I mean, those are all kind of remove, repair, I mean, they're not exactly the same things. So you could allege facts like defendant failed to remove it. You could even just track the language. Defendant failed to remove it. Defendant failed to repair the situation. Defendant failed to correct the condition. I still think that's kind of one element collectively, but I would, even though it's an or, failed to make reasonable efforts to warn. Meaning if, let's say the defendant had put up like a warning, jewelry cleaning shit show on aisle 5, like that could make him escape liability. Right? You see that? Like if there were huge warning signs, like flashing red, warning, jewelry solution all over the place. Don't clean today, Portia. That could totally undercut the claim. So even if he didn't correct the condition, if he warned about it, that could undercut. I think you want to plead facts that make it clear that he didn't do either one. Does that make sense, even though it's an or?
I had said, I didn't allege a specific fact, but I had said defendant failed to warn of the hazardous condition.
I think that's fair. I think that's fine. The key is, what I'm looking at, and really, it's all good, but you guys are doing great. I mean, the key is, are you alleging facts which, if true, would establish all of the elements of the cause of action? And if you can do it in alternative ways, I think allege both, because that helps you. That strengthens your case. What about causation? Now, let me, before I move on to the next element, which is causation, a few of you had, and therefore the defendant failed to use reasonable care, or breached his duty. I saw somebody, one person, I think, maybe two, said breached his duty. What do you think about that? Breached his duty of care. People are like, no, yes and no. I mean, right, the rule, the technical Temple, Smith, and Couples is don't allege legal conclusions, right? Because they're not ultimate facts which help you establish each of the elements of the cause of action. Don't allege legal conclusions because the defendant's just going to deny them. The counter argument, or the asterisk, the footnote is, if the point of them really isn't to prove up your claim, if you know a denial's coming, but you're just trying to kind of use it as a transition, like the defendant owed the plaintiff a duty of care. Next allegation. And then you have some of these, you're going to get a denial here, but it functions almost like a heading. I don't think that's bad. I mean, what you don't want is to mix an ultimate fact that you want to get a denial or an affirmance to, like an admission or a denial to, mixed with a legal conclusion, because then you're not going to glean any helpful information. But if you just have a pure allegation that's purely a legal conclusion, I mean, it's not the preference. I would prefer if you did a heading. But if it's just serving as a transition sentence, you're going to get a denial, but it might keep you straight with how you're kind of alleging your facts. Does that make sense? So, yeah.
It's in your breach section, because I've proved some of our complaints at work, and we have defendant had a non-delegable duty to keep the property located at the actual store, reasonably safe to inspect the property and take active steps to make the property safe.
Yeah, I mean, I think that's probably right. The non-delegable duty is probably the accurate, I mean, it's kind of a jerk when I say it in that tone. But you're right. I mean, I think you're kind of into the more, nitty-gritty of premises liability. That's probably right. And I think that language sounds accurate as far as they would of premises liability claim. For our purposes, I think you wouldn't need it.
Okay.
But it's just, I mean, this would not, you would need more than like, there's a pretty deep business owner that you would probably want to include like a lot of allegations
Right.
about like who had control over this and yeah, no, I mean, I think that's fair. You wouldn't need it for our class, but I think you could definitely include language like that. The key ultimately, Hannah, is that you would want to just make sure that whatever you have to plead in your jurisdiction is something that you included factually. So I didn't mean to be flippant. I mean, I kind of was.
I've seen it at work. And
Yeah.
I know, like, we have other things that bolster what that is, but just as like
Yeah.
a legal conclusion.
No,
to
totally.
put in there that, I know they'll probably deny it, but
Yeah.
at least it's in there to help keep everything straight.
I think that's good. You know, it's interesting though. Like a non-delegable duty could also function just as a factual allegation, right? Because like whether you delegated, it's a little bit. I don't know if I'd want to say non-delegable duty, but you'd want to say something like the defendant did not delegate any responsibility for the premises to another individual. Because then it's more like a fact that clearly tracks the language of the element. So that's good. I mean, if you're on that, I mean, you're thinking about how can I sufficiently plead up all of the elements of the cause of action. And I think you're probably right, that's one of them. Because it kind of goes, I mean, some of this is in there. It's not written in as sophisticated of a way, but I think the idea is that other individuals didn't have access to this, right? Like, oh, well, maybe it was just a member of the public walked into the break room and threw jewelry, because people do that. Or just, I mean, shit, if people do this, they just do all sorts of things. But no, I mean, I think they try to make it clear in the facts that's like, look, you know, this is just an area that only the defendant and his employees had control over. Okay, so that's my note about legal conclusions. What about causation? Any reaction to causation? No, nobody. Causation. Dimitri, what do you think? Did you have anything about causation?
What is? No, I'm just kidding. Yeah, I said because the plaintiff slipped and fell on the jewelry solution that had been leaked from the 5-gallon bucket on the floor in the employee break room, she suffered 2 broken bones in her right. So I basically just listed the injuries.
Yeah, I think because of or as a result of this incident, plaintiff was injured. I think you want to come up with some sense. And causation really isn't that. You know, the reality is you might want to think about but-for and proximate cause. But I've always found that, especially in kind of tort cases, premises liability cases, if you've got the duty established, if you've got the breach, all of the sub-elements of the breach, causation really is nothing more than maybe one sentence, possibly 2. Like when the plaintiff went into the employee break room to clean, she slipped in the leaked fluid, slipped in the leaked fluid and fell. Something like linking when she did this happened. And you'd want to, it's really getting close to the injuries, but it's a linkage. It's just a short allegation written in a neutral way that links the situation with the actual incident. What actually, she fell. That's really all it takes. It's much more streamlined than the rest of it. Yeah, I think you had a question.
Yeah, so in the breach of duty part, I think the first thing you had was the on November 1st portion of the employee.
I actually included that here under duty, but you know, because that's kind of like he owed her a duty of care, not just historically because she had a history of providing cleaning services, but he owed her a duty of care on that occasion because she went in. I mean, I didn't say it like that. I didn't say he owed her a duty of care. I just said on November 1st, 2019, plaintiff went to defendant's store to provide cleaning services.
So I put that under the causation part, and I feel like I put like a set of facts in the wrong place. Like, do you think it would have been better? I obviously think it's better in the duty part.
I mean, I think you could do that. You know, it's interesting because it goes to something else I saw, which is the extent to which people felt like they needed to be kind of sequential. I mean, this story kind of operates in a narrative way, so it's all kind of sequential. I don't think you necessarily need to have your complaint written where everything happens in a chronological way, so you can have things lower that maybe predated what comes above, because the key is you want facts which line up with your elements. But to me, the reason why I included it up above is it wasn't so much that she walked into the business to provide the services that established the causation. That's what provided the duty of care, right? He owed her a duty of care because on that date she was providing cleaning services. But the reason why the causation happened is you're linked, or why you have causation is you're linking the situation, the leaky fluid on the floor, with the harm. So you would want something like when she went into the break room to clean, which also gives rise to the duty. I mean, that's related to duty. When she went into the break room to clean, is she slipped in the leak fluid, fell, and I think you could even say, and suffered injury. Now that sounds like it's getting to damages, but you're going to detail the damages in subsequent allegations. Does that answer your question? I guess the way I would say it is, I don't necessarily view the act of her on that date going to the business as the causation element. I view the act of her on that date going to the business to clean being an allegation that establishes that he owed her a duty of care, and it was that she went into the break room and slipped and fell on that fluid and was injured that provides the link between the breach and the damages. Yeah.
I think you listed how the employee break room was under exclusive control in.
Yeah.
I put that in causation just because it kind of tied it into it being 100% his fault.
I think that's fair, and a couple people did that, right? Which is they said, look, that was, they kind of broke, most people who did that, and I think if I remember there were like 4 of you who did that, did two separate allegations. Said something like, I took a note on that too, where is that? I'm glad you brought that up.
Yeah, I didn't even add headings. I missed last class, but like it was in that section, like that realm of.
Yes, some people said the defendants, when plaintiff went into the employee break room to clean, plaintiff slipped in the leak fluid, fell, and suffered injury, and then said the employee break room was under the exclusive control of Mr. Grantham and his employees. And some people even then said you could have another line in there, or you could even have a third allegation, which is the break room is not accessible to the public. I think that's fair. Yeah, some of these, there's no perfect answer to any of these questions, right? Like you could make an argument that also goes to his, that's kind of these facts, that goes to his breach, like he knew about it, he was under control. But I don't think there's anything wrong with saying like, look, she went into the break room, which he had control over and was injured. That's why he caused her injury. I think that's fine. That does help prove up the causation. I think that's very good, actually. Okay, what about damages? A little more straightforward. Yeah, what do you think?
I just said as a direct result from this slip, the plaintiff broke 2 bones in her arm. Just listed all the.
I kind of went E through G, or A through H, and just did them as separate allegations. Yeah, as a result of her fall, plaintiff broke 2 bones in her right arm. Plaintiff also broke her right hip. And some people broke it up even more. Plaintiff had to have hip surgery. Plaintiff went to physical therapy. Plaintiff is having trouble walking again, although that's a little bit ambiguous. Yeah?
So wait, for damages, I just listed it all as one sentence, and I guess that's not what you did?
No, what I did was I did allegations in the fact pattern. I did E, okay. F, and then I broke up F. See how there's 2 sentences in F? Yeah. I broke it up. So I had one, my first damages was E. My second was the first half of F. My next one was the second half of F. Then I had G without the amount, because I struggled with what you said. But I don't think you're wrong. Like if you included that, I don't know that